I wanted that clear in the record.
Appreciate that.
And for the other parties.
All right. Thank you. Professor Hamilton, go ahead and raise your right hand. Do you swear or affirm that your testimony you are about to provide is true and accurate?
I do.
Thank you.
Professor Hamilton,
Yes.
are you the same Neil Hamilton who caused direct testimony to be filed in this docket on July 24th?
I am.
And are you sponsoring Hamilton Direct Exhibits 1 through 5?
I am.
And do you affirm that testimony as if you were asked the same questions here today?
I do.
Do you have any additions or corrections to make to that testimony?
I don't think so.
The county's tender Professor Hamilton for cross-examination.
Thank you. Did you have any admissions?
Thank you. I would like to move his testimony and his direct exhibits at this time.
Are there objections?
No objection.
Seeing none, the board will admit. Mr. Leonard?
Thank you, Your Honor. Good evening, Professor.
Good evening.
I've just got a few questions for you.
Okay.
As I review your testimony, I take it that you take the position that neither state nor federal law can preempt a county ordinance.
I take the position that neither federal or state law preempted the ordinances in this situation. Certainly, federal law can preempt a local ordinance.
And state law could preempt a local ordinance too, couldn't it not?
Certainly through express preemption, yes.
There are other forms of preemption, correct?
There are. They aren't certainly as direct or as effective as express, but
You used in your answer previously, I think the phrase preempted with respect to the ordinance in this case. Which ordinance were you speaking about?
well, we're talking about the county zoning ordinances that are in question.
You would acknowledge that the United States District Court for the Southern District of Iowa recently did preempt a county zoning ordinance, would you not?
That there's a temporary injunction against one of the counties.
Sir, you don't sit on that court, do you?
I don't think any of us here sit on that court.
You have a mention in your testimony about the Dakota Access case.
Yeah, there's certainly a mention of it, and I noticed on one of the rebuttals, or whatever you're calling it, someone had a rather twisted interpretation of that comment, yes.
Are you personally aware of whether the Dakota Access Pipeline or its owner sought zoning permits from any of the counties that it traversed before it was constructed?
Whether they sought them beforehand?
Yes.
No.
Are you personally aware of whether any county issued a zoning permit to Dakota Access prior to its construction in the state of Iowa?
No.
I don't have any other questions. Thank you, Your Honor.
All right. Are there any other questions from the part? Oh, Mr. Oscar?
Professor, I'm seated in probably the worst seat in the room
That's okay.
to question the person up there. So if you want to turn your chair a little bit.
Go ahead and turn your mic too, Professor.
So the important thing is, above all, is that you speak into the microphone.
Sure.
So that we can all hear you, including, most importantly, the court reporter. I want to unpack your discussion of county authority and talk about what boards of supervisors do. And let's talk about drainage for a minute as a way to explore that. You're familiar with Iowa drainage law, right?
Yes.
And we've had testimony in this hearing, and I've heard it said many times that much of Iowa, particularly northwest Iowa, basically was a swamp before settlement began. Would you agree with that statement?
I think it's more commonly north central Iowa than northwest Iowa, but
Big parts of our state required drainage infrastructure in order to convert the ground into a state where it could be consistently farmed in a productive way, right?
yes, correct. And we passed a constitutional amendment to
Sure.
allow the creation of drainage districts for that purpose.
You've read the chapter of the code devoted to Iowa drainage law, right?
Well, I don't want to say I've read it all because it goes on for, 80 or 100 pages, and unless you're representing drainage districts, there's not a lot of reason to read it all, but I'm familiar with most parts of it and how it operates.
Well, I'll ask you a few questions about it. So when
Your Honor, I'd like to object at this point. We're not offering Professor Hamilton for his expertise on drainage districts, and he doesn't discuss it in his testimony. There are and have been other witnesses who do address drainage districts, but we're not offering Professor Hamilton for that purpose.
Okay, thank you. Mr. Oscar, can you rephrase and kind of tighten down?
I'm going right to what boards of supervisors do, and that talks about county powers here, which is what the witness has been proffered for. Professor, you're familiar that when drainage districts were formed, or could be formed today, that the board of supervisors has a role as a county to facilitate the creation of a drainage district, right?
Yes, and that that the supervisors can serve as the board of trustees of the drainage district if the district chooses to have the supervisors play that role.
Sure. And the reason you need a drainage district that the supervisors would form is it doesn't do a farmer any good to put drain tile in if there's no place for the water to go off of his farm, right?
Certainly. The part
So
of
that
Iowa
would-
where I'm from, you would tile and you'd have drainage and
Sure.
it would lead to the creek.
Your Honor, we're way into tile and drainage, and I'd like to renew my objection on that point.
Okay, thank you. Mr. Ostrom, can we limit your questions to the scope of the
I'd
testimony?
be almost done without those two objections, so I'm going towards the goal here.
Okay.
So, and you'd agree with me that counties have the power of eminent domain in the formation of a drainage district, right?
Well, in the formation of a drainage districts gives the district the power over the properties that are then identified in the district, and the drainage district has the power of eminent domain to put in the mains through the drainage district.
Sure.
So, okay.
And that's an example of using eminent domain law in order to facilitate private economic activity, right?
As it was specifically authorized by a constitutional amendment recognizing the importance of drainage to the development of the state.
The development of privately owned farmland, right?
Which involved millions of acres of the state, yes.
Privately owned farmland can be enhanced in its value through the use of eminent domain, right?
Your
Well,
Honor,
certainly the part of the land that's being eminently domained across hasn't been enhanced in value. The adjacent property might be if, in fact, that eminent domain's used to create some type of infrastructure or service that would benefit the rest of the land.
Sure.
I'd like to
I
object.
think Mr. Whippel wants to get an objection in there.
Your Honor, I think at this moment, Mr. Oskren is attempting to take advantage of the fact that Professor Hamilton is a law professor and range outside of the purpose of his testimony, which is not drainage districts, not eminent domain, and not the broader question of public convenience and necessity, and not any economic analysis, but simply zoning. And so if he'd like to ask about county powers to zone, we would not object.
Okay.
All right, Mr. Ostrom, that's the next question on my outline.
All right, let's get there. Thank you.
Now, you'd agree with me, Professor, that county zoning ordinances cannot be applied under Iowa case law in a way that's arbitrary and capricious, right?
Well, if a court would hold that how it was being applied was arbitrary and capricious, yeah, the zoning would give way.
And zoning laws are, to be valid, are ones that regulate how an individual uses their land to not interfere with how another person uses their land, right?
No, not necessarily. I mean, certainly zoning has the effect of minimizing conflicts between individuals, but the major purpose of zoning would be to carry out the land use plan as was developed by the Planning Commission and laid out in the maps. It may have the effect of changing the dynamics between neighbors, but in many situations it would probably enhance the use of the neighbor's property. I think you're conflating zoning and nuisance. And while they're first cousins by marriage, they aren't the same thing.
As I understood your testimony, your claim is that the agricultural exemption to a county's zoning power does not prevent it from using its zoning laws to regulate the placement of pipeline infrastructure under the ground. Is that correct?
Because the placement of pipelines wouldn't be an agricultural use.
So the answer to my question is yes.
Okay, yes.
Okay. Are you familiar with the scope of pipeline infrastructure in our state?
Yeah, we have thousands of miles of pipeline in our state.
We've had testimony that's over 40,000. Are you aware of that?
I think I saw that in someone's testimony. I'm not sure that any of them are the type of pipeline that's in question here, but
can you point me to an Iowa Supreme Court case which has held the point that you asserted a moment ago, that the placement of a pipeline underground transforms the use of the land from agricultural?
Well, I'm not sure that a court case would actually be asked that question. If the question was that somebody tried to prevent a regulation of a pipeline because it was in violation of the agricultural exemption, that would deal with that issue.
My question might not have been clear. What I'm asking is, can you point me to an Iowa Supreme Court case, the holding of which is the same as the assertion that you have made about the ability of the county to zone agricultural land?
I'm not sure that I follow that question, if there's a question in there. So you wonder whether there's a Supreme Court case that holds what?
That would be authority for the proposition that you have stated in your testimony, that a county, notwithstanding the agricultural exception to its zoning powers, can regulate pipeline infrastructure on agricultural land.
No, I don't know that I know of a Supreme Court case in which that actually issue has been joined. I also don't know of one in which they said they couldn't.
So let's talk about preemption.
Okay.
I want to ask you some questions about your testimony. The commission staff has been great so far putting documents up on the screen. I'll ask them to go to your direct testimony on page 16. And we'll look at line 22, which is the start of a question, and then I think it'll carry over into the following page. So do you see the portion of your testimony that we have up here on the screen, and we may need to...
Can we take it up just a little freckle higher above these screens? There we go. Well, I guess I have it here too. Okay, what's the question?
So I want to ask you about so you respond to the testimony of a summit witness, Eric Chauvenac, correct? Is that right?
I think so. This is the one where he said they've looked at the county zoning ordinances in the 30 counties. Mm-hmm.
And that sentence on line 5 of page 17, while not a lawyer, he, meaning Chauvenac, concludes that such ordinances are preempted. What did you mean when you said, while not a lawyer?
He's not a lawyer. I think he says that, doesn't he, in his testimony?
So it's, I mean, essentially an assertion of your expertise over his, claiming that you, as someone with legal training, are more qualified to opine on this preemption question than he is, right?
Well, I might agree with that second part. I'm not sure that I said it in that sentence. I'm just repeating the fact that he said he wasn't a lawyer.
And what did you mean when you communicated that?
I suppose I was prefacing the nature of his conclusion.
Which, that it should not be given weight because he's not a lawyer, right?
It should be given the weight that he gave it himself by announcing that he wasn't a lawyer.
Now,
I didn't dismiss it. That's what he said. He's not a lawyer, but while I'm not a lawyer, I believe these are preempted.
certainly, his testimony would have been filed before Chief Judge Rose entered a preliminary injunction against the enforcement of Shelby County's ordinance, right?
I don't think it was it?
Well, we know now that he's been proven right, at least so far, by Judge Rose's order, correct?
He's been proven right in one county and one ordinance, yes.
And that order from Judge Rose issues a preliminary injunction against Shelby County's ordinance on both state law preemption and federal law preemption, right?
I believe it does, yeah.
The federal law preemption being that federal law gives PHMSA, Pipeline and Hazardous Materials Safety Administration, the authority to issue regulations about pipeline safety, and specifically says state laws on safety are unenforceable, right?
I believe that's what PHMSA says, yeah.
And that was the basis for Judge Rose's preliminary injunction on federal preemption grounds, right?
It's a safety issue, yes.
And the state law preemption issue is her finding that the Iowa Utilities Board is charged with decisions about the placement of pipelines and the safety issues that surround them, right?
She says that it was impliedly preempted by how she interprets the IUB's authority, yes.
So the answer to my question is yes.
Yes.
Now, you're familiar with an Iowa Supreme Court case called Goodell versus Humboldt County?
Yes, a home rule case. Mm-hmm.
And for the record, that's a case that can be found at 575 Northwestern 2nd, 486, a 98 decision of the Iowa Supreme Court. Now, that's a case that dealt with whether a county could enforce regulations that controlled how large...
Your Honor, I would like to object here.
State your objection.
Might we save a discussion of Goodell until the briefing? We would suggest that'd be a better place to engage in this discussion.
Mr. Osborne, can you get to your question?
Well, I was in the middle of asking it, Your Honor, but the witness has made assertions about what state law preemption is and is not of county home rule authority, and I'd like to test his knowledge. I'm happy to brief this.
I'm happy to give you a
Professor,
pretest on that question.
Professor, the way this works is...
Hey, hold on. Listen, everybody's going to have to sit down and just be patient for a minute. So, Mr. Osborne, please go ahead and finish.
So, I would be happy to just brief the point, but the counties have tendered a witness to talk about what the law is, and if the IUB is going to rely on the witness's statement about what the law is, then the witness should be tested on his knowledge of the law.
I'd like to respond to that. The counties have proffered Professor Hamilton to talk about the relationship to county zoning, which is not precisely the same thing as the scope of state and federal preemption.
Okay, thank you. Mr. Oscar, if we can get to your question quickly, please.
Yes. The Iowa Supreme Court in that case found that local regulation of large animal confinement operations was preempted by state law, correct?
Yeah, because the state law said that, yes.
And in that decision, the court said that if a county seeks to exercise a power that applies throughout the entire county equally, then that is not an exercise of the county's zoning power, right?
I'm not sure I would interpret it that way, but go ahead.
Are you familiar with the court's statement on that point about zoning power?
And so what's the question? I mean, if the question deals with whether this is a home rule case or not, or whether it deals with the fact that the counties are using a specific power that had been granted to them, the Goodell case involved a county essentially trying to find a workaround to the limitation on the county's ability to regulate feedlots. And it was doing it by trying to bootstrap on some other provisions and justify them as a form of county zoning. In this situation, as I understand it, the question directly involves the issue of the application of county zoning. And so there's no home rule question because county zoning exists. And the counties that are involved here have zoning ordinances, some of which specifically refer to pipelines, some of which don't. But in all of these counties, they have land use authority. And so the question of how the counties are trying to use their land use authority, I don't think involves a parallel to the Goodell case.
Let me ask my question this way, and I'm just going to quote from page 507 of the opinion. And for staff, I realize we can't put this on the screen, so I'm just going to read it, but it's in the part of the opinion titled summary.
I object to reading in case law.
Mr. Oscar, you can reply if you like.
Well, the witness has been tendered as to testifying about the county's home rule and zoning authority, specifically zoning authority permitting this, and I want to test him on his knowledge of the distinction between home rule authority and zoning authority, which goes to the basis of his legal opinion.
Okay. Sustained as far as it is to reading specific case law. We can all check that out in the brief. So if we can go ahead and get to your question as it pertains to the testimony, please.
Professor Hamilton, is it your testimony to this board that a county can validly use its zoning power to enact a standard that applies equally throughout the entire county?
Yes.
Okay, thank you. That's all the questions I had, Your Honor.
Okay. Thank you. Let me see. Let me find my list here. I don't know who was first, if it was Jorde or Oscar. Grunegan. Ms. Grunegan.
They're both long names. Professor Hamilton,
Ms. Grunegan.
I wasn't going to ask you questions, but I've changed my mind after, just to clarify a couple of things on Iowa drainage law. You mentioned there's a constitutional provision regarding drainage law. Does that constitutional provision specifically give the right for eminent domain for drainage districts?
I believe it does, but I don't have it in front of me.
Is the staff able to pull up Section 18, or Article 1, Section 18 of the Constitution?
Objection.
State your objection.
Your Honor, I'll repeat Mr. Whipple's objection with respect to legal conclusions about drainage law.
puts me in a bit of a consistent box here. So, Ms. Gruenhagen, if we can get to the point of your question, please.
If drainage districts are given an eminent domain authority in the Constitution,
Sure.
then the issue of private use is no longer a constitutional issue.
Well, that was the point I was headed at when I referred to the constitutional authority for them to use eminent domain, yes. And so it would be a classic example of the use of eminent domain because they've been granted to it, and as a government entity or one that's been given the government's power, they have the power to do it, yes.
Thank you. And then regarding the definition of agriculture, is there a long line of cases defining agriculture in the zoning context?
Yes, a lengthy line of cases. The
So-
first LRV article I wrote was on this issue of freedom to farm, understanding the agricultural exemption to county zoning in Iowa, and it's been litigated a number of times since then.
And is the most recent the Lang case in
I think so,
2013?
yeah.
And if something is not within that definition, would you consider it to be agriculture?
That question of what's agriculture depends on who you ask in many ways, because in fact the purpose of that first article that I wrote, I collected I think 30 county zoning ordinances and was amazed at the array of different ways that counties had found ways to define themselves around the agricultural exemption with acreage limits and income requirements. And so the question of what's an agricultural use may well depend on why we're asking and what the statute is.
Did the Supreme Court define it in the Lang case a little more clearly than it had in the past?
I think so, yeah.
Thank you. No further questions.
Thank you. Mr. Jorde, you were next on the list now that I found my list.
Thank you. Sir, you're going to have to help me because I got so confused during the gentleman questioning from down there. He stated in the form of a question something to the effect that counties can regulate pipeline infrastructure on ag land. Is that a statement that you believe to be true, that he was restating what you had said, or what do you recall about that?
I think he was perhaps restating what I was saying, and the point I was making was that while the pipeline, for example, is going through much of the land is agricultural land, and so it's land that's zoned agricultural, that a pipeline wouldn't be a principal permitted use in an agricultural area. And so as a result, a pipeline or any other non-agricultural use, an industrial site, trying to go on agricultural land would either require rezoning or, in this situation, more likely to require some type of conditional use permit. But the point would be that the county could in fact regulate it when it was even going in on what was otherwise agricultural land. Yes.
Okay, and so the use of the word regulate, I just want to understand what you're getting at if you use that word. Is it your opinion that zoning ordinances are by the very definition regulations on whatever is zoned in those ordinances?
Well, I may be using regulation different than other people may use it as a term of art, but if it's the issue of the government being able to control how a particular piece of property is used or establishing standards for its use, then zoning is a form of land use regulation.
Correct. And so a setback is a setback a tool that has, and in Iowa, has been delegated to the counties, and that is within the county's power as a tool within their zoning regulations.
Yeah, setbacks are fairly commonly used, both in a county setting, but in municipal settings as well. We may not call them setbacks, but the fact that you may have to have a 15 feet on the side of your property from the neighbor's property is a form of a setback.
But would you agree that even if a county had a setback, for instance, you can't construct XYZ within 1,500 feet of a hazardous pipeline, is it your testimony that then is a per se regulation, a safety regulation, or can a county simply have intelligent land use setbacks that aren't necessarily tethered to safety?
Well, certainly land use goes much beyond safety. I mean, if you look at authorizing statutes for county zoning or municipal zoning, there's a whole series of reasons why the zoning power is granted, and promoting the general health, safety, and welfare may well be one of them. I think, if I can say, that in the context of this pipeline regulation, there seems to be an inducement on the part of some parties to use the word safety in a very broad way as almost a universal solvent to kind of wash away any other type of restriction. And when it comes to county zoning, there are certainly safety concerns underpinning some of the aspects of county zoning, but that's not the only reason why you have county zoning. You have it to promote enhanced values of property, to promote land use planning, right, in terms of how the uses are located next to each other. And so safety is one factor, but certainly not the only factor.
In your analysis, have you become aware that PHMSA safety regulations only have to do with safety standards such as construction, the strength of a pipe or the length and the amount of welds and those kind of things, and that it doesn't go into anything that could potentially theoretically have to do with safety? Are you aware of that?
Objection, Your Honor.
Objection.
Twofold. First is the issue of friendly cross. I don't think it's a secret that the counties that Mr. Whippel represents and the folks that Mr. Jorde represents are on the same side of this case. This is no longer cross-examination at all. It's just additional direct by another party on the same side of the case. The second piece of my objection would be that we heard several objections from Mr. Whippel about how narrow Professor Hamilton's written testimony was. I do not see a lot of discussion of safety standards and specific PHMSA regulations in that testimony, so I would repeat that objection.
Okay, your response?
Yeah, well, first of all, the table to my left couldn't be more friendly. I mean, they're going and they're eating lunch together, they're hanging out together, laughing together. I mean, whatever that was just a substitute for Summit's counsel cross-examining this witness. I've never met this man before in my life. I didn't even read his direct testimony, so I'm trying to clarify some things that became very confusing to me during, I guess, the ethanol plant or whoever that was questioning. So, I'm picking up on things that have already been put out there by the lawyers down there. So,
Okay.
So was there a question? Is there a question
Professor
on the table?
Hamilton, just hold on.
May I respond briefly to that?
Yeah, please do.
Mr. Ostergen's clients are on the opposite side of the case from this witness, and so they were cross-examining. What I'm suggesting is that what Mr. Jorde is doing is simply additional direct of a witness on the same side of the case.
Okay. Sustained as far as friendly cross, can we please just limit our questions to the context of the testimony?
well, I guess my questions go to the context of the cross, which apparently had nothing to do with the testimony.
I
But
think we already ruled on the objection, Mr. Jorde. You go ahead and ask your next question.
okay, well, I want to talk about safety because that was brought up. So you would agree that in terms of zoning ordinances, that the theory of safety could be just one component in how we get to, for instance, setbacks.
Sure. Objection.
State your objection.
Goes the same objection as previously. I don't recall safety being brought up, and we've heard several times that this witness is testifying about county zoning ordinances, not with respect to PHMSA regulations or safety regulations. I believe Mr. Jorde is who brought up safety.
Okay, I don't know what to say. I heard safety from down there, but anyway. So in terms of your testimony, you were asked specific questions about this Judge Rowe's order. In that order on the injunction, do you recollect if Judge Rowe specifically made a finding as to setbacks, or was she concerned with other aspects of the ordinance?
Boy, that's a good one. I think that it was other aspects of the ordinance.
Okay, all right, you're right. So
Okay.
that's all the questions I have. Thank you.
You're welcome.
Okay. Are there any other questions for from the parties? Thank you, Professor Hamilton. Okay,
Yeah.
Mr. Whippel.
I would like one or two redirects, but if that's after the board, that's fine.
Nope, redirect. We'll be right after the board. I just want to make sure we get all the parties. So, go ahead.
Professor Hamilton, on page 21, lines 22 through 23 of your direct testimony, you recommend the board establish certain minimum required separation distances from cities and occupied structures.
Yeah, I was asked if I had any other recommendations. Sure.
Do you have a specific recommended different distance?
You mean, do I want to suggest 500 or 1,000 or 1,200? I guess my recommendation would be that the board exercise its judgment as to what it believes is a reasonable distance, and that one of the ways that you would be able to develop that would be by looking at what the counties have in fact included in their ordinances, because those county land use authorities and planners, I think, are probably closest to the situation concerning their areas and their properties. There are several counties that have enacted zoning ordinances that were somehow responsive to this pipeline proposal, but most of the county ordinances have in fact been in place for many years, and so to the extent that they have setback requirements, we have, I think as we heard in earlier testimony today, setback requirements for any number of other activities in the state, confined animal feeding operations, for example. And so I don't necessarily want to propose a number, but I would think that the board, with your expertise and your resources, could identify one, and in fact, the other legal authorities in the state would probably defer to it because you were the ones that established it.
And would it be correct that that recommendation is for CO2 pipelines alone, not other types of pipelines?
Well, I think my testimony was specific to this case, and so we're dealing with a CO2 pipeline.
On page 23 of your direct testimony, you describe Shelby County's ordinance, which is under a federal temporary injunction. Under Shelby County's proposed setback requirements, do you know if it would be possible for a pipeline to be constructed in Shelby County?
I think there's some debate about that. I believe that the applicant here has alleged that they couldn't. I'm not sure that the Shelby County supervisors or zoning officials would necessarily agree with that. It might require identifying a different place for the pipeline than what's being proposed, but I don't believe that the county set out with the goal of, well, let's redline the whole county so that a pipeline's not possible. They identified a series of uses and what they believed were reasonable setback requirements relating to those uses. Now, granted, that may in fact present certain challenges to being able to identify the corridor, but that's a different question.
Similarly, on page 29 of your direct testimony, you described Emmet County's separation distances. Same question, under Emmet County's proposed setback requirements, would it be possible for the pipeline to be constructed in Emmet County? Do you know?
Can we roll it up a freckle more? I would think you could fish your way through Emmet County without a challenge of staying away from a church by a half mile or a town by 2 miles. There aren't that many incorporated cities in Emmet County.
Okay. On page 33, lines 13 through 14 of your direct testimony, you state there is a concern about the impact of the Avenue of the Saints Industrial Park.
I reflect the fact that I believe that Floyd County has in fact alerted them to that effect, and they included some correspondence to them, yeah.
So would a permit be required to cross this section of land, or would it be permitted as an industrial use?
You mean when the pipeline was going across the portion of the property that's zoned industrial? That would depend on whether or not a pipeline was a permitted use in the industrial district. Since the pipeline has industrial-like dimensions to it, I think it's probably safe to assume that it might be relatively easy to in fact get approval in that industrial district for an industrial type use. There the question would probably be more the actual physical location of it as to how it impacted other existing properties. You know, nobody's going to build on top of a pipeline, for example.
On page 43, lines 20 through 21 of your direct testimony, you state the easements obtained in the county are not valid unless the conditional use permit was first obtained.
Where am I at here? Now we're
Lines
in
20
Hardin
and
County.
21. Yep, Hardin County.
Okay, and this is Hardin County informing them to that effect, right? Hardin County told Summit that they needed to obtain a permit to cross the road right-of-ways, and that they had to get a conditional use permit to do that, and otherwise, just as it reads there, the easements obtained wouldn't be valid unless there was a conditional use permit had first been obtained. And that was a fairly this is, as you can see in my testimony, this is the only county that in fact imposed this requirement, that they tied the road crossing permits to the application for the conditional use permits relating to zoning. And you had to somehow get the pipeline from one road to another road, right?
So you're saying that the easements obtained in Hardin County are not valid, in your opinion?
I'm saying that Hardin County told them that, yes. I didn't independently tell them that.
Under that assumption, would Summit Carbon need to revise its petition and request eminent domain for that county?
Well, that's an interesting question. I hadn't necessarily thought about that, but what you're saying is that the way they would avoid the county trying to apply the conditional use requirement is that they would just use eminent domain across the whole thing. Well, that would be another way to try to address the issue, I guess. It would certainly seem to broaden the need for the use of eminent domain, though. And would create an interesting precedent if you were going to use eminent domain across the whole county to try to get a corridor, but.
Okay, no further questions, thank you.
Okay. Mr. Meyer, I see your tent is up, and Mr. Whippel also had redirect, but Mr. Meyer will call this redirect as well since you're sharing this witness, correct? Okay. Go ahead.
Let me go first quickly. Professor Hamilton, is it your understanding that the Judge Rose ruling is currently being appealed?
Yes.
And if we could just quickly turn to your direct testimony at page 10, line 18, if we could show the witness that part of his testimony.
Okay, 10, line 18.
Professor, at this part of your direct testimony, is this where you are addressing agricultural use and the scope of county zoning powers?
Yeah, that language that's quoted there from 335.2 is the agricultural exemption to county zoning, yes.
So is there any need to identify a Supreme Court case if we can refer to this statute as you've done here?
I'm a little hard of hearing. What?
Is there a need to identify a specific case if you've addressed it here at lines 18 to 20 in terms of the scope of the agricultural exemption to county zoning?
Not necessarily, no.
That's all my redirect, Your Honor.
Mr. Meyer?
Thank you, Your Honor. Sir, I'm going to ask you some questions based on exhibits 3, 4, and 5 of your direct testimony.
And we have those that we can pull them up.
There's exhibit 3.
These look like it's something you're familiar with.
That's why I'm asking you about it.
Okay.
You reviewed this document, right?
Mm-hmm.
That's a yes.
Yes. Oh, sorry. Yes.
Sorry. And if you can scroll down a little farther, a little further, please. Just keep going until. Keep going. All right. On page 2 of 2, you agree this is a email from a Bill Sullivan on July 10?
That appears to be what it is, yeah.
Right. And they're seeking permits to cross roadways?
Mm-hmm.
That's a yes?
Yes, yes.
Okay.
Yeah.
Can we look at exhibit 4, please? Or is that all of them put together? All right. So there's exhibit 4. This is some communications in February of this year, is that right?
Yes.
And again, that's gentleman Bill Sullivan seeking permits in Hardin County related to this project.
Yes.
All right, can we have exhibit, if we haven't had 3 yet, I'll have you pull that one up. And in the May time period, is this, again, Summit is through Bill Sullivan seeking permits in Hardin County?
This is May of 22, yes.
Okay, I'm sorry. So does it appear that Summit agrees with you that they have to follow Hardin County's permitting process?
Objection.
State your objection.
1 calls for legal conclusion. 2, this is not cross-examination. It's just further direct of this party's own shared witness.
Yeah, Mr. Meyer, if we can kind of try to tighten this down to redirect of previous.
It's aiming toward a question that he was asked about the federal court ruling.
Okay. We'll try to get there then, please. Thank you.
So, regardless of the federal court ruling, would this demonstrate that Summit is acknowledging its need to comply with local permitting in Hardin County?
Objection calls for speculation as to what Summit has in its mind. Also, I guess calling for this witness to speculate about written communication that he's not a party to.
Just asking for his own opinion.
The witness may answer, and then can we try to tighten our questions down, please?
Yes.
Well, again, I believe that they acknowledge that they need to comply with local permitting. The question is which local permitting?
Did you watch or are you familiar with some of the testimony that was provided regarding permitting through Summit's witness, Mr. John Schmidt?
I have not been watching. I have to say I'm not a faithful viewer. I didn't want to prejudge my appearance, so
Okay.
you may have to fill me in if he said something important.
Well, if you aren't, I was gonna ask a question about his testimony, and
Okay.
since you're not familiar, I won't. No other questions, thank you.
Thank you. Are there any questions from the parties following redirect? Okay. Professor Hamilton, you're excused.
Thank you, Mr. Chair. It's good to see you again. It's been many years since
Been a
you were in
long
my
time.
classroom. Thank you.
Good luck tomorrow. Okay, we intend to gavel in tomorrow.